Hello, thank you for joining us today. We would like to make this virtual event a pleasing and productive experience. To make this happen, the organizers request all participants to observe the following house rules. Display your full name and office. Please use the chat function to provide comments and the Q&A box to ask questions. The moderator will then read and direct questions to the panel. For documentation purposes, this event will be recorded and shared on our ASEAN-ACT Partnership Hub portal. Translation is available by clicking on the interpretation button and choosing your preferred language. At the end of the event, please take a few minutes to fill out the feedback form. As we are in a virtual environment, we will be kind to one another in case of internet connection issues. We will expect unavoidable technical difficulties. Feel free to join back if you're disconnected. Everyone's patience will be greatly appreciated. Thank you for your attention.
All right, thank you for that. So all of our speakers today will be speaking in English except for Pa Agustri, who will discuss in Indonesia Bahasa. So you may click on the desired interpretation channel to listen to our speakers. So we have customized channel for English, Cambodian, Bahasa, Indonesia, Lao, Thai, and Vietnamese. And if you want to listen in Myanmar or Burmese, please choose the Portuguese channel. That's what has been customized for Burmese. The Zoom recording, PowerPoint presentation, and materials from this webinar will be uploaded right after the webinar is concluded this afternoon in our ASEAN-ACT portal. The link to this portal will be posted in our chat box as well. Now, to formally open the webinar and deliver the welcome and keynote remarks, we are very pleased to have Australian mission to the ASEAN acting counselor Daniel Seaver in a pre-recorded video message.
Good morning and welcome to our partners and other anti-trafficking advocates from around the ASEAN region and beyond. It's always a pleasure to open the ASEAN Australia Counter-Trafficking webinar series and see that we're joined by such a diverse range of policymakers, practitioners, researchers and advocates with an interest in adaptive and innovative justice responses to trafficking in persons. I would like to warmly welcome and thank our esteemed speakers, Judge Adel Majed, Vice President of the Court of Cassation, joining us from Cairo, Egypt. Pamela Bowen, Senior Policy Advisor, Crown Prosecution Service, joining us from the United Kingdom. Dr. Marika McAdam, International Law and Policy Advisor, ASEAN-ACT, joining us from Melbourne, Australia. Attorney Agustri Hartono, Head of Pre-Prosecution Counter-Terrorism and Transnational Crimes Directorate, Indonesia Attorney General Office, joining us from Jakarta, Indonesia. We have a truly global and expert panel today who will be formally introduced later on in the program. Today's webinar, the 9th in a series of 10 webinars hosted by ASEAN-ACT, is about vulnerability and trafficking in persons, the evidentiary challenges in cases. Our topic today is particularly significant in the month of 16 Days of Activism, a global campaign which runs annually to end violence against women and children. Trafficking in persons is one of the worst forms of violence against women and children. According to the UNODC's Global Report on Trafficking in Persons, 79% of trafficking in persons involves sexual exploitation, and the victims of this crime are predominantly women and girls. Traffickers prey on vulnerable groups who may be poor, isolated, and marginalized within their communities. Traffickers often use violence or other forms of coercive control to intimidate victims in their recruitment, and victims may be subject to further violence and coercion from their employers and others who exploit them. This horrific crime can be reduced with an enhanced understanding of dimensions of vulnerability and how these intersect to make particular individuals and groups more susceptible to trafficking and exploitation. Of equal importance is to consider how counter-trafficking in persons responses take into account the vulnerability of victims when determining the outcome of a trial and the remedies and support available to victims. As many in this virtual room will be acutely aware, certain individuals and groups, including women and children, ethnic minorities, stateless peoples, and people with disability, have always been vulnerable to trafficking. Unfortunately, COVID-19, like any other major crisis, has exacerbated the risks for these groups and created new vulnerabilities for groups such as migrant workers and those working in the informal sector. Many governments in the ASEAN region have taken steps to cushion the impact of the pandemic through social protection and increased government spending on health and other social services. While these measures have provided some degree of protection for economically and socially marginalised groups, many are slipping through the cracks, and the economic impacts of the pandemic will be felt in Southeast Asia for years to come. In the context of trafficking in persons, international and regional legal frameworks provide a direction on how the concept of vulnerability should be used in determining whether human trafficking has occurred. The Palermo Protocol, in defining trafficking in persons, includes abuse of power or of a position of vulnerability as one of the means by which a person can be trafficked. Further, the region's legal instrument, the ASEAN Convention Against Trafficking in Persons, especially women and children, more commonly referred to as ACTIP, refers to the abuse of a position of vulnerability as an important aspect in determining the outcome of trafficking in persons cases. Neither instrument, however, provides a clear definition of vulnerability and what this means in the context of human trafficking. Clearly recognising, defining and proving the vulnerability of trafficked victims, especially women and children, throughout the investigation, prosecution and adjudication process is central to our discussion today. As ASEAN's longest standing dialogue partner, Australia is committed to continuing its 17 years work with ASEAN partners to strengthen justice responses to all forms of trafficking. Our support has a dedicated focus on protecting victims of human trafficking and those who are most vulnerable to trafficking, especially women and children. We work with ASEAN member states to facilitate dialogue and good practices on victim-centred approaches for police, prosecutors, judges and frontline responders to trafficking in persons. To improve the way victims are treated in the criminal justice system, we have developed 8 key indicators together with target ASEAN countries to encourage victim-centred practices in courts. The indicators serve as a framework and a reference point to assist the formal justice sector, in particular courts, to protect the rights of trafficked persons. 4 key data indicators have also been created, which we hope will be adopted by ASEAN member states across the region as a tool to enable the collection and publication of vital information about trafficking cases that can be accessed by policymakers, advocates, and most importantly, users of the justice system. We have also developed a Do No Harm guide for our partners to promote the use of trauma-informed, gender-sensitive and child-friendly practices when interacting with victims and potential victims of trafficking. This will soon be accessible through the ASEAN-ACT website. And together with the ASEAN Commission on the Promotion and Protection of the Rights of Women and Children, we are working on developing a regional Do No Harm guide for frontline responders across ASEAN. Today, we're very fortunate to have a panel of experts who, with their extensive knowledge and expertise on this subject, will provide some clarity on the concept of vulnerability and the implementation of measures provided in the Palermo Protocol and other legal instruments. Our panelists will provide some clear examples of how the abuse of position of vulnerability has been appreciated and used to secure convictions in trafficking cases. We hope that today's conversation will stimulate an exchange of ideas and facilitate new connections between those working in the ASEAN region on improving the understanding and application of the principle of vulnerability in trafficking in persons cases. And on a final note, I must raise Australia's grave concerns about the situation in Myanmar. Australia supports ASEAN's crucial role in responding to the situation. ASEAN-led efforts represent tangible steps towards ending the violence and a commencement of dialogue between all parties concerned. We reiterate the importance of the full and timely implementation of the 5-point consensus, agreed by ASEAN leaders and the leader of Myanmar's military in April. And we call for the immediate release of those arbitrarily detained. Again, welcome everyone, and I look forward to an insightful webinar ahead. Thank you.
Thank you very much, Acting Councillor Daniel Seaver, for the very warm welcome. It has certainly set the tone of the discussion today, and we are all looking forward to the fruitful discussion as well. So, um, to capture this moment, let us first take a group photo. This is one of my and Kem's favorite part. May we request everyone to put on your camera, please, and Kem will give us the cue.
Thank you so much, Sardine. If you can ask, please, our distinguished panelists,
Yes, so
Attorney
please.
Agustri, to switch on the camera, please. And once Pak Agustri is ready, we'll be having a group photo. There, okay, there she is. Okay, this is about my most important contribution to this webinar. So may I kindly ask our panelists to look at your camera in 3, 2, and there you go. Another one, and this time, if I may ask our panelists to wave to your camera like this. In 3, 2, and all right, there you go. Okay, and back to you, Darlene.
Perfect. Thank you so much, Kem. So before we dive into the discussion, may I share with you very briefly some great feedback we got from our previous webinar, which was conducted last 17th of September, about online sexual exploitation of children. So from this slide, as you can see, 93% said that the topic was relevant to their work and that the event was very useful, and 94% said that they learned something new and the speakers were very knowledgeable. We also took note of some comments and suggestions from the participants, and where one prosecutor commented that there was, because after listening to the webinar, that there is a need to reevaluate current tools and techniques in the investigation to help address the increasing cases of online sexual exploitation of children. And on the suggestion on having an NGO speaker, we did have NGO speakers before in our previous webinars, and we are very happy to tell you that there will be again NGO speakers in our next webinar on December 9. We would love to continue this series next year. So all of your comments or suggestions are very well taken and valuable to us to help us improve our format and to better serve you as the key actors in the counter trafficking in persons field. So please help us complete this survey. The link is in the chat box, and you will also receive a certificate of attendance for your records upon the completion of the survey. All right. So given our topic today on vulnerability and trafficking in persons, its evidentiary challenges, we hope to draw some answers on some or all of the questions, such as how does one recognize the vulnerability of a victim and prove its existence? How does one prove that the vulnerability of the victim was abused or taken advantage of by the trafficker as a means to undertake the action and achieve the intended purpose of exploitation? Or would proving the existence of victims' vulnerability alone be sufficient, or should the prosecutor prove the abuse of the victim's vulnerability, or both? So before we invite our first speaker on the floor, we would like to draw out some thoughts from you by posting here some poll questions. Your responses are gathered to check the pulse of the virtual room and gauge sentiments and awareness on the issues. So ASEAN-ACT will not use the data for any other purpose. Kem will display on the screen the poll questions. There are only 2 questions. If I may read this poll question. So based on your understanding, which term most relates to vulnerability? Is it weakness, lack of choice, beyond one's control? Then second question, in your view, what action should be prioritized to improve justice response in recognizing and proving vulnerability in courts? Number 1, training on vulnerability and evidence needed, research on vulnerability factors and successful prosecution and good practices, clear policy guidance on vulnerability and victim protection. So there you go. These will be quick, just 2 clicks and you're done. We will present the poll results after the presentations of our experts. Don't be shy, you don't need to identify yourself. So no worries, just click on. All right, you can still click on this later as we move on. So now allow me to introduce our first panelist, logging in from Melbourne, Australia. Dr. Marika McAdam is an independent international law and policy advisor. There you go. Yes. And she has worked on human trafficking and migrant smuggling issues globally with the United Nations and others, and is currently serving as an advisor to the Bali Process Regional Support Office and the ASEAN-Australia Counter-Trafficking Program. In her counter-trafficking work, she has trained law enforcers, prosecutors, and judges, addressed senators and parliamentarians, and carried out research globally on the challenges of implementing international law in practice. She is the author of several technical publications on rights-based criminal justice response to counter-trafficking, specifically on the issue of vulnerability in the context of trafficking. Dr. Marika interviewed 40 criminal justice practitioners across 11 countries, resulting in the UNODC issue paper on abuse of a position of vulnerability in trafficking, in the trafficking definition. I will post the links to this issue paper in a while. So Dr. Marika will share her expertise and knowledge on the concept of abuse of position of vulnerability as a second element of trafficking in persons, and how this interacts with the other elements of TIP, including on the conceptual challenges raised on the abuse of position of vulnerability. So it's an honor for me to give the floor to Dr. Marika McAdam.
Thank you so much, Darlene, for the introduction and indeed for organizing this extremely timely session, which I'm thrilled to kick off. I think this issue could not be more relevant for today's counter-trafficking challenges. We've long known that abuse of a position of vulnerability is an extremely common means used by traffickers, and vulnerability is such that traffickers don't always need to use violence and force like they do in the movies, but it's often more subtle means that are used by them. But these days, of course, we're in complicated times with COVID and restrictions in place because of it. And all projections suggest that vulnerability is only going to increase, which means, of course, that this issue should be an area of our focus. So let me kick off with some big considerations on this issue. I appreciate, Darlene, that you mentioned this study, because by way of background, the UN Working Group on Trafficking in Persons many years ago pointed to a whole bunch of issues that it found to be challenging in understanding and applying the definition of trafficking. Now, one of them was abuse of a position of vulnerability. And here I should say in very clear terms at the outset, what I'm concerned with is not vulnerability on its own, vulnerability of victims of trafficking, but I'm looking at abuse of that vulnerability by traffickers for the purpose of exploiting people. So we're all very common and commonly aware and probably sick to death of looking at this tripartite definition of trafficking with the acts, the means, and the purpose. But I wanted to emphasize that abuse of a position of vulnerability is a means of trafficking, and that's my focus of it. So as it is understood in the international definition of trafficking, and indeed in the ASEAN Convention Against Trafficking in Persons, which replicates that international definition. So this study that I had the great privilege and pleasure of doing many years ago was conducted in, as you mentioned, it was a total of 13 countries, 12 of which I had the great pleasure of visiting for the purpose of conducting this study. Now, we selected these countries with a view to capturing perspectives from origin, transit, destination, also with a perspective of gathering insights from common law, civil law, Islamic law countries, to really get at a range of different perspectives and identify the challenges of what it means to abuse a position of vulnerability and counter trafficking. So the range of countries that are represented was extremely diverse and led me into the path of some incredible experts, including, I'm delighted to say, two of whom being on this panel, being Judge Liddell and Prosecutor Bowen, who have got extraordinary insights. So that methodology resulted in a paper that I drafted with my dear colleague Anne Gallagher, and that offers up some diverse insights into what abuse of a position of vulnerability means. Now, the overarching finding is that APOV, as we call it, just to be efficient, is really a gatekeeper concept that can expand understanding of trafficking in persons, or indeed can contract it. And that raises challenges and opportunities in practice. So some key findings on this. First of all, it's very clear that abuse of a position of vulnerability is widely accepted and understood by states and criminal justice practitioners within them as being absolutely critical to how human trafficking is understood. So that's quite clear. However, in practice, the interpretation of it and the application of it is inconsistent in sometimes quite problematic ways. Now, often what we found is that this relates quite significantly to the type of exploitation at issue, and indeed contextual issues such as the cultural and even gender dimensions at play in a given country context, and indeed for a given victim profile. So to simply explain that, there's often widespread acceptance, for instance, of the idea that a victim of a young female victim who may be naive and innocent being subject to sexual exploitation through abuse of a position of vulnerability. That's quite easy for criminal justice practitioners to very readily understand. However, there's less acceptance of the notion of, for instance, a middle-aged man whose vulnerability may be, for instance, a criminal record or a history with drugs and alcohol, being that position of vulnerability being abused in order to exploit him in forms of labor, or to even test this challenge even further. Think about the idea of vulnerability being a religious belief being abused for the purpose of exploitation in terrorism or such crimes. So the spectrum of what we're talking about here raises real challenges. Also, another thing we encountered was that abuse of a position of vulnerability as an element of the definition of trafficking is very often simply conflated with just vulnerability itself. And that occurred in many of the conversations I was having around the world with practitioners on this issue. There was a lot of talk about vulnerability, but less insight into how that vulnerability is abused. And that there is key to our understanding of this very serious crime type. Now, the consequences of this misapplication and misunderstanding of abuse of a position of vulnerability are quite significant. There's criminal justice implications, of course. If the definition of trafficking is expanded, that means that we may be capturing as a serious organized crime something that is just not meant to be. But conversely, if the definition is contracted, it may mean that we are missing out on identifying victims of trafficking and bringing traffickers to justice. And of course, related to that too are the human rights implications of misapplication of this concept, not just for victims, but also for accused traffickers or traffickers, and indeed others. For victims, where we fail to identify, we fail to protect. And this is often the case where criminal justice practitioners, including frontline officers, don't understand that victims may be abused by subtle means, but they're looking instead for force. It also may mean that people are misidentified as victims of trafficking who are just not. And this raises questions, for instance, of agency and whether someone who is in a vulnerable position because they need work can choose to do certain types of work. And that, of course, emerges in situations where there's raids and rescues of people, for instance, in the sex industry. And human rights implications for accused persons too, where we may may be inappropriately prosecuting people for serious crimes who are simply not serious organized criminals. Just by way of example, let's take a hypothetical scenario of a migrant in an irregular situation who goes up to someone and says, please, 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 I need work. And the person says, well, I can't afford to give you work, but you can stay here, you can, I'll give you some food. And that can be very easily packaged as a person living in substandard conditions, working for less than minimum pay. And that person could be construed as having abused that position of vulnerability if he knew of it, which he did. I say that as a quick hypothetical, but in reality, there have been cases that look much like that, where a prosecution for trafficking has resulted from such a scenario. So to conclude very briefly on some of the guidance points that we arrived at, the key point is that abuse of a position of vulnerability requires those two things. It requires the existence of vulnerability, and that assessment is done on a case-by-case basis, taking into consideration personal, situational, and circumstantial situations of the victim. That vulnerability can be pre-existing or it can be created by the trafficker. But vulnerability alone is not sufficient to prove this second element of the trafficking offence, but it occurs where it's intentionally taken advantage of to commit an act, whether recruitment, transportation, transfer in the definition of trafficking, such that the person believes that this is the only choice available to them. And that's a reasonable belief in light of that victim's circumstances. Some evidentiary considerations that arise in this. First of all, we have to remember that abuse of a position of vulnerability can be the means by which any of the acts are perpetrated, and it should not be more or less easily found in relation to some forms of exploitation or others. The type of exploitation, whether for the purpose of sexual exploitation, forced labor, forced marriage, criminality, shouldn't be relevant to the assessment of whether credible evidence suggests that a potential trafficker has abused that situation for the purpose of that exploitation. And credible evidence is essential to show that there was an intentional abuse of that vulnerability. And that evidence must point to the fact that the means used was sufficiently serious as to vitiate the victim's consent. It's not enough for the knowledge of that the potential perpetrator of that vulnerability. We have to clearly prove that abuse of a position of vulnerability acted in a way as to make the victim's consent irrelevant. Expert evidence may be useful in pointing to evidence of abuse of a position of vulnerability, and we find this time and time again, the relevance of experts, social workers, cultural advisor, psychologists, to point to why a victim may be believing or acting in certain ways. And importantly too, we need safeguards to be put in place to allow for a common sense approach to all of this. And the more I engage with the definition of trafficking, the more it strikes me that it's possible to make it very, very broad or very, very narrow. The important thing is that we have to remember that trafficking in persons is a serious crime. It shouldn't be easy to prove. It should be challenging to prove on the basis of credible evidence. So we have to constantly uphold the integrity of our criminal justice approach by ensuring that what we are doing makes sense, including with these gatekeeper concepts such as abuse of a position of vulnerability. I will leave it there, Darlene, and I look forward to hearing the insights from my colleagues. And I just wanted to point to these resources for further information, and I hope you'll download those, and I look forward to the discussions afterwards. Thanks so much, Darlene.
Thank you so much, Dr. Marika. Yes, we have posted the link, and I hope, we do hope you'll have the time to go over and read those. And I know, Marika, we wish we had more time for you to discuss about the issue paper, but you were able to comprehensively at least give us an overview of that document and talk about the importance of this understanding the vulnerability. And one highlight for me actually is that both existence of vulnerability and the abuse of the position of vulnerability must be established by credible evidence. So thank you for emphasizing that, Dr. Marika. So on to our next speaker. We have who is someone, and as you mentioned, Dr. Marika, we are very lucky to have all three of you, who have contributed to the UNODC issue paper on vulnerability. Our second speaker is calling in from Cairo, Egypt. Justice Adel Magat is the Vice President of the Egyptian Court of Cassation, and he is also a regional expert in combating trafficking in persons and smuggling of migrants. Justice Magat is a specialist, academic, and practitioner with more than 3 decades of professional experience in criminal justice reforms, investigation, prosecution, and adjudication as a prosecutor and a judge. He was appointed public prosecutor in 1987 and served in different judicial capacities until his appointment as judge and vice president of the Egyptian Court of Cassation in the criminal chambers. He is also the founder of the Department of Legal Research and International Relations at the Court of Cassation and acted as the director of this department from 2009 to 2011. In his current capacity, Justice Magat reviews and adjudicates high-profile criminal cases, including terrorism and human trafficking. Justice Magat has extensive expertise in implementing international law principles at the regional and national level. He has advised the ICC, or International Criminal Court, Office of the Prosecutor, and the League of Arab States on international criminal law issues. From 2010 to 2013, he was appointed as the expert advisor on human trafficking to the League of Arab States and the Anti-Human Trafficking Coordination Unit. In his capacity, he has drafted the comprehensive Arab anti-human trafficking strategy, amended the Arab model law on combating human trafficking crimes. He was also selected to participate in the UNODC expert group meetings and has participated in drafting various UNODC issue papers on combating trafficking in persons. Justice Adel has authored several articles and books on trafficking persons and was awarded the title of Honorary Professor of Law from Durham University. Let us hear from Justice Adel, his expertise and knowledge in adjudicating trafficking in persons cases involving abuse of position of vulnerability. Justice Adel, please, you now have the floor.
Good morning. Good morning, Ms. Darlene. Good morning, everybody. Warm good morning from Cairo, Egypt. And I really feel that I am in these beautiful Asian beaches right now. I don't know why, but I am very pleased. I am very pleased to be invited to this very important, very technical webinar addressing a very technical concept, which is vulnerability in cases and in the context of trafficking in persons. So thank you for inviting me. And just before I start my presentation, I would like to shed some light on a very important issue that should be interested for all participants from all legal systems. For interest, it is important to note that when examining the case law on trafficking in persons in common law system and in civil law system, you will find that the main principles, the basic principles are similar. This is an important issue to note, and you will see this when I will address or present some cases from the case law in the Egyptian courts. You will see the principles are the same in all jurisdictions when it comes to trafficking in general and how to address the concept of vulnerability in specific. So please allow me to share my PowerPoint presentation. I hope it is shared now.
Yes, we can see it. Just
Perfect.
Isabel.
Perfect. Perfect. In Egypt, in our law 64 for 2000, Egypt is one of the Arab countries that gave important and significance to the issue of trafficking and issued a comprehensive law, as a matter of fact, which tackle every concept in trafficking in persons and focused on the concept of vulnerability, as you can see. And Egypt is one of the first countries who added intentionally another term which equals vulnerability, or which resemble vulnerability, or which reflect vulnerability, which is the concept of need. And you will see later how I am going to apply this concept in some of our cases, the concept of need. Maybe it sometimes it reflects the issue of economic need, poverty, but in some cases, courts have established their judgments on the concept of need as reflecting a position of vulnerability. According to the case law of the Egyptian courts, the existence or non-existence of a position of vulnerability is a subject matter to be determined and decided by the criminal judge himself in his decision on the merits. And after that will come the role of the Court of Cassation, and please allow me to explain to participants what is the Court of Cassation role in brief. The Court of Cassation is the highest level in the judicial system in Egypt. You can call it like the Supreme Court. And our main role is to review and to guarantee the unification of all principles on law and certain cases among all jurisdiction. The court can deduct, this is one principle that we established at the Court of Cassation, that the court can deduct from the factual circumstances of the case that the vulnerability of the victim was being taken the advantage by the trafficker as a mean undertaken the action and achieve the intended purpose. In the Egyptian case law, as many case law in other jurisdictions, types of accepted evidence. Firstly, testimonial evidence by victims, for example, and even the confession of the trafficker himself could be relied upon as a testimonial definitive evidence in our Egyptian legal system and the Egyptian case law. A judge can establish his conviction only on confession. After that, we have, of course, documentary evidence, documents, invoices, for example, and then real evidence, forensic evidence, for example. As I mentioned before, in both civil and common law systems, courts rely upon both oral and written evidence. I will explain more when presenting two cases, specific cases on the issue of vulnerability. It is crucial either in the investigation process or in the adjudication level to secure the victim cooperation in the criminal proceedings. It is very important. So it is the role of the police officers who should be specialized the investigators, the prosecutors, to give the victim the required environment that makes him comfortable and relaxed. Usually, victims of trafficking persons, as we all know, are very tensed, and sometimes they are distracted. So we have to assist them in all type of procedures. And for this issue, I would like to address a principle that was provided by the Court of Cassation. In the Court of Cassation, we would accept the testimony of the victim, even it differ from a stage to another stage in the investigation and in the trial itself. Because we believe that the victim, because of the pressure and the pressure was occurred by the traffickers who compelled him to act in certain ways, this constitute a great pressure on the victim. So we totally understand how the victim can change his testimony in some stages. Corroborative evidence is also important. As I mentioned, we can base our conviction only in a victim testimony, only on an offender confession. However, it would be much more appropriate if it is supported by other circumstantial evidence. The Court of Cassation has already held that the judge can establish the conviction from all type of evidence, as I mentioned before, presented before him, including circumstantial evidence, as long as it supports the victim's testimony or the defendant confession and establishes a connection between the defendant and the crime committed. Role of subordinated evidence of corporation is to establish this connection and relation between the acts committed and the defendant. I have brought today two cases as an example of vulnerability. The first one of them relates to the concept of need, and the second one of them relates to the concept of vulnerability, pregnancy. And allow me to tell you a very interesting conversation that happened between me and Dr. Marika. It was about the pregnancy issue. Is pregnancy itself put a woman in a position of vulnerability? In general, no, because some women are pregnant, but they are not weak. They go to their work, they can handle their issues. But when it comes that other circumstances, surrounding circumstances are affecting this pregnant woman, we can here say that we have a real situation of vulnerability. I will show this later. Poverty and need. In this case, the defendant took advantage of the particular economic vulnerability, as I mentioned, the issue of need of the victims. It is important to mention here, most of the victims were minors. And their need for money, so economic vulnerability, need for money, to compel them to donate their blood for money. This is the first step. Donate their blood. As a matter of fact, it is not a donation. You can say it is a compelled donation, a compelled transfer of their money. Then after that, they sell their blood for private hospitals. The trial court found that the abuse of the dire economic straits of the victims was sufficient in achieving a conviction of trafficking. In this course, also, abuse of a position of vulnerability was the only established mean. And this is another issue that I have to stress and to focus on. and maybe Dr. Marika in presentation mentioned this. It is amazing to notice that many cases in human trafficking and convictions are based only on the concept of vulnerability. We have to stress on this issue. And this is another case, the issue of pregnancy. How could a pregnant woman be a subject to trafficking because of her pregnancy, which we consider a weak situational issue that makes her weak? In this case, the defendants took advantage of the particular vulnerability resulting from unlawful pregnancy, which took place outside marriage relation. And please let me shed some light on the cultural and social circumstances surrounding such cases. If the woman is from Europe and have conceived her pregnancy in out of marriage relation, this might be acceptable in the community. But in Egypt, especially in Upper Egypt, it is not acceptable. And you may hear the stories about women in this very conservative society have been killed because they have conceived and they become pregnant in out of marriage relation. So this is here the culture, the social surrounding that affect the woman. So just realize and just imagine this woman when she has pregnancy, out of marriage pregnancy, what she'll do? She will run away from her community. She will run away from her village. She will run away from her city just to go to Cairo, where she can find people who can help her in solving her problem, which has been arised by the issue of vulnerability here. Okay, so in this case, they offer the woman to sell her baby. The defendant then subsequently sold the baby to others. So she will have her pregnancy, deliver her baby, then she will just sell it and accept to sell it because she has no other choice. In this case, abuse of a position of vulnerability was the only mean relied on by the defendants. They exploited the woman's out of wedlock pregnancy and her fear of its being revealed in order to seize her baby and to sell it, thus constituting an abuse of her position of vulnerability. I think I have already exceeded my 10 minutes. This is why at this last PowerPoint slide, I mentioned if time permits, and I know that time will not permit. So here it is a recommendation here. This is my recommendation because it is a very important webinar, as I mentioned. I advise the organizers to collect the presentation submitted and to try their best to issue a booklet or pamphlet on these issues: the role of the investigators, the role of the prosecutors, judges of the High Court, to establish a solid above case. And thank you for your kind attention.
Thank you very much, Justice Adele. We'll take note of that excellent recommendation. And of course, thank you so much for the comprehensive presentation. Very informative to know about Egyptian law on the expanded definition of the abuse of position of vulnerability, that it includes now the abuse of victims' needs and capturing extreme poverty as a key vulnerability factor. And very interesting too, the cases that you've shared, particularly on the vulnerability resulting from an unlawful pregnancy, which the traffickers took advantage of to seize and sell her baby. So this sample case actually allows us to look at the bigger picture and how pressures and circumstances affects the decision and testimony of victims in a TAP case. So thank you again, Justice Adele. Now we're very happy to have a distinguished prosecutor calling in from Jakarta, Indonesia. We have attorney Pa Agustri Hartono. He is currently the head of pre-prosecution and counterterrorism and transnational crimes directorate from the Indonesian Attorney General Office. He has been working as a prosecutor since October of 2005 and is a holder of a master's degree in law. Attorney Agustri will share his expertise and knowledge on the concept of vulnerability, including the sharing of good practices and challenges experienced in prosecuting PIP cases involving abuse of position of vulnerability. So Attorney Pa Agustri, you have the floor, please.
Ya, terima kasih atas waktunya. Terima kasih juga kepada penyelenggara yang telah mengundang saya di acara yang sangat baik, sangat penting. Tadi sudah banyak hal yang sangat baik yang dipaparkan oleh Ibu Dr. Marika, oleh Pak Adel. Yang memang materi yang dipaparkan sangat penting sekali, terutama bagi aparat penegak hukum dalam penanganan perkara tindak pidana perdagangan orang. Kami di Indonesia ketika pandemi COVID-19 menyerang dunia termasuk Indonesia sekitar Maret 2019, bahwa salah satu pihak yang paling berpengaruh terhadap dampak pandemi, karena begitu ada pandemi, bidang kesehatan, bidang kesehatan, ekonomi itu sangat berpengaruh, pemberhentian hubungan kerja di mana-mana, pengangguran di mana-mana, mencari pekerjaan sulit, mencari nafkah untuk hidup sulit, yang pada akhirnya kaum perempuan dan anak adalah merupakan golongan yang paling rentan, terutama ketika berbicara keadaan keluarga yang sedang membutuhkan keuangan untuk bertahan hidup, tetapi kepala keluarga tidak bekerja, mau tidak mau perempuan dan anak juga ikut membantu mencari nafkah. Nah, dalam kondisi-kondisi seperti itu kemudian di lapangan banyak terjadi kerentanan-kerentanan yang dimanfaatkan oleh pihak-pihak yang tidak bertanggung jawab. Di Indonesia ketika pandemi melanda, kami menyesuaikan sebentar saya tampilkan paparan. Nah, sudah bisa terlihat paparannya ya. Di Indonesia ketika pandemi melanda, hukum acara pidana Indonesia beradaptasi untuk dapat tetap terlaksana dan terselenggaranya proses penegakan hukum dari mulai penyidikan, penuntutan maupun persidangan, sehingga pihak aparat penegak hukum dari kepolisian, kejaksaan, termasuk Mahkamah Agung membuat MOU pada waktu itu untuk dapat dilaksanakan persidangan online, termasuk perkara TPPO di sana, yang kemudian dasar itu oleh Mahkamah Agung ditetapkan melalui Perma tahun 2020 sehingga pelaksanaan persidangan TPPU bisa dilaksanakan secara online. Nah, posisi persidangan secara online dalam hukum acara ini sangat penting sekali dapat dilaksanakan karena mengingat Indonesia negara kepulauan, posisinya sangat banyak pulau dan cenderung perkara TPPO itu melibatkan korban yang tinggal di pelosok-pelosok, sehingga dengan pelaksanaan persidangan secara online ini tetap dapat terlaksana dengan baik, tidak mengurangi substansi perkara. Selanjutnya, hukum di kami di Indonesia itu sangat menjunjung tinggi keberadaan perempuan dan anak, termasuk perempuan dan anak ketika berhadapan dengan hukum, baik posisinya sebagai korban maupun sebagai pelaku. Nah, di setiap peraturan perundang-undangan Indonesia banyak mengatur tentang hal ini. Kemudian Kejaksaan Agung melalui peraturan pedoman nomor 21 tahun 2001 ini menetapkan sebuah pedoman tentang asas keadilan bagi perempuan dan anak dalam penanganan perkara pidana. Nah, dalam pedoman ini sudah tersusun secara teknis lebih detail bagaimana melindungi dan menjunjung tinggi hak-hak dari perempuan dan anak, baik dalam proses penanganan perkara tahap penyelidikan sampai kemudian proses penuntutan. Kemudian masuk ke tindak pidana perdagangan orang, sedikit saya ingin menginformasikan ketentuan hukum yang mengatur tindak perdagangan orang di Indonesia. Ketika kita berbicara apa itu tindak pidana perdagangan orang, tentunya karena memang negara-negara yang meratifikasi protokol Palermo dan ketentuan yang lain, bahwa perdagangan orang terbagi ke dalam 3 elemen pokok, ada proses atau tindakan, ada cara, dan ada tujuan. Dan cara yang salah satunya adalah penyalahgunaan posisi rentan. Di dalam hukum Indonesia, saya ingin menyampaikan terlebih dahulu beberapa penekanan terhadap ketentuan undang-undang, karena ketika kita berbicara praktek terkait dengan proses penyidikan maupun penuntutan atau persidangan, ketentuan ini sangat penting sekali dan sangat berpengaruh terhadap sebuah proses persidangan. Di Indonesia di dalam Undang-Undang Nomor 21 Tahun 2007 itu disebutkan bahwa kita akan berbicara mengenai pasal 26, persetujuan korban perdagangan orang tidak menghilangkan penuntutan tindak pidana perdagangan orang. Kemudian di pasal 30, sebagai salah satu alat bukti yang sah, keterangan seorang saksi korban saja sudah cukup untuk membuktikan bahwa terdakwa bersalah apabila disertai dengan satu alat bukti sah yang lain. Nah, pasal 30 ini menarik ketika kita akan berbicara praktek Indonesia, bagaimana kondisi di lapangan yang dihadapi oleh aparat penegak hukum, terutama oleh jaksa penuntut umum. Kemudian di dalam pasal 34 di Undang-Undang 21 tahun 2007 dikatakan bahwa ini yang mengakomodir sebelum timbulnya perma tentang persidangan online di undang-undang ini sudah diakomodir, itu yang mengatur bahwa saksi atau korban tidak dapat dihadirkan dalam pemeriksaan sidang di pengadilan. Keterangan saksi dapat diberikan secara jarak jauh melalui alat komunikasi audio visual. Artinya di undang-undang kami di Indonesia telah mengakomodir ini. Di luar ketika ada keadaan bencana seperti COVID-19. Di Indonesia, tindak pidana perdagangan orang ini adalah delik biasa, bukan delik aduan. Artinya perbuatan ini ada bisa karena dilaporkan oleh para korban atau juga dilaporkan oleh pihak lain. Pihak lain ini bisa oleh masyarakat umum maupun oleh aparat penegak hukum. Contohnya penyelidik ketika menemukan adanya perbuatan tindak pidana. Saya sampaikan sedikit beberapa modus tindak pidana perdagangan orang yang banyak terjadi di Indonesia. Yang yang pertama mengenai perekrutan tenaga kerja Indonesia ke luar negeri. Kemudian ada juga perekrutan tenaga kerja Indonesia untuk domestik. Kemudian ada juga prostitusi. Kemudian di Indonesia juga banyak ditemukan pengemis paksa. Kemudian juga ditemukan pertukaran pelajar, tapi ternyata TPPO, hanya modus saja pertukaran pelajar. Kemudian juga peredaran obat terlarang, duta seni, pertukaran duta pelajar, eksploitasi ABK, anak buah kapal, pekerja anak buah kapal, kemudian pengantin pesanan, dan modus yang lain masih banyak. Tapi beberapa modus itu adalah modus yang paling banyak terjadi di Indonesia. Kemudian dari beberapa modus itu banyak yang melibatkan korban perempuan dan anak. Ada beberapa modus yang paling banyak itu adalah mengenai perekrutan tenaga kerja Indonesia, TKI ke luar negeri. Nah, ini paling banyak modus yang melibatkan korban perempuan. Biasanya ke luar negeri itu banyak ke negara di Asia maupun di Timur Tengah, seperti Abu Dhabi, Dubai, Arab Saudi, dan lain-lain. Kemudian juga modus operandi TPPO dengan korban perempuan dan anak di Indonesia itu banyak juga dengan modus prostitusi. Prostitusi ini banyak di Indonesia, korbannya perempuan dan anak. Ada juga korban yang warga negara asing yang menjadi korban di Indonesia. Berbicara mengenai kerentanan, posisi rentan, bicara penyalahgunaan posisi rentan, saya akan menerjemahkan dulu bagaimana hukum di Indonesia mengatur mengenai posisi rentan. Di dalam Undang-Undang 21/2007 tentang TPPO memang disebutkan salah satu cara adalah penyalahgunaan posisi rentan. Tetapi dalam undang-undang ini tidak menyebutkan dan mengatur apa yang dimaksud dengan posisi rentan. Kemudian di beberapa ketentuan yang terkait dengan TPPO juga tidak mengatur apa yang dimaksud dengan posisi rentan. Sehingga kami, aparat penegak hukum, khususnya kami, selaku jaksa penuntut umum, kami melakukan penafsiran gramatikal. Karena penafsiran gramatikal dari sudut bahasa itu yang paling mudah kita dapat. Apa yang dimaksud dengan posisi dan apa yang dimaksud dengan rentan. Salah satunya adalah posisi. Dalam Kamus Besar Bahasa Indonesia, Indonesia diartikan sebagai letak, kedudukan atau jabatan atau pangkat. Kemudian rentan itu mudah terkena, pekah, mudah merasa. Ini secara terminologi dari penafsiran gramatikal. Kemudian dalam proses penegak hukum termasuk dalam persidangan, ketika kita ingin menunjukkan apa yang dimaksud dengan penyalahgunaan posisi rentan, penafsiran hukum apa yang bisa kita pakai. Salah satunya di Indonesia yang kita pakai adalah pendapat ahli TPPO, yaitu dari Dr. Ninik Rahayu. Dr. Ninik Rahayu mengatakan bahwa posisi rentan diartikan sebagai suatu keadaan yang di dalamnya terdapat ketidakseimbangan status atau kedudukan antara dua pihak, yaitu korban dan pelaku. Pihak pemberi kerja meskipun secara normatif memiliki hubungan kerja yang koordinatif, tetapi secara sosiologis keduanya tidak memiliki posisi dan kondisi yang sama. Pemberi kerja memiliki kuasa dan atau kendali yang lebih bebas, mengarahkan dan menentukan jenis, bentuk, jumlah upah atas pekerjaannya. Sedangkan penerima kerja dalam posisi dan kondisi menerima pekerjaan karena banyak faktor. Miskin, tidak berpendidikan, korban kekerasan dalam rumah tangga, korban perkosaan, dan lainnya yang menggambarkan kerentanan dan menjadi sebab yang bersangkutan diposisikan rentan menjadi korban. Nah, pendapat ahli ini adalah salah satu rujukan yang kami pakai dalam melakukan dalam menuntut atau mendakwa pelaku tindak pidana perdagangan orang di persidangan. Kemudian bagaimana cara membuktikannya terhadap posisi rentan, terhadap cara penyalahgunaan posisi rentan. Di sistem hukum pembuktian kami yang diatur di dalam Undang-Undang Hukum Acara Pidana pasal 184 ayat 1, sistem hukum kami menyebutkan jenis alat bukti yang sah itu ada 5, yaitu keterangan saksi, keterangan ahli, surat petunjuk, dan keterangan terdakwa. Ditambah lagi dengan Undang-Undang TPPO sendiri, ini menambah alat bukti dengan perluasan alat bukti, yaitu alat bukti elektronik sebagaimana diatur di dalam pasal 29 Undang-Undang nomor 21 tahun 2007. Alat bukti elektronik ini banyak, luas. Saya pikir juga terjemahannya hampir sama di beberapa negara yang lain. Kemudian dalam proses persidangan, bagaimana persyaratan sebuah untuk melakukan pembuktian terhadap penyalahgunaan posisi rentan. Karena hal ini sangat penting sekali ketika kami jaksa membawa sebuah kasus, sebuah perkara ke persidangan, bagaimana ketika masih dalam proses penelitian berkas, kita sudah bisa merumuskan bahwa cara yang dilakukan di dalam tindak pidana perdagangan orang ini adalah posisi rentan. Nah, posisi rentan yang disalahgunakan, yang tadi kami jelaskan, kami mempergunakan salah satu pendapat ahli, Dr. Nini. Persyaratan yang pertama adalah kita perlu membuktikan adanya ketidakseimbangan antara kedudukan dan pelaku terhadap pemenuhan hak dan kewajiban sesuai dengan peraturan perundang-undangan yang berlaku atas penerimaan pekerjaan yang dilakukan. Salah satu bentuknya misalnya bahwa di setiap ketentuan perundang-undangan, misalnya pemberi kerja, penerima kerja, korban ini akan melaksanakan pekerjaan sebagai TKI di luar negeri, ada ketentuan yang mengatur mengenai pekerja migran di Indonesia. Ada syarat-syarat yang harus dipenuhi oleh pemberi kerja, dan si penerima kerja juga ada hak yang harus diterimanya. Nah, ketika si pemberi kerja dengan pengetahuannya, kemudian si penerima kerja karena dia butuh pekerjaan, kemudian pemberi kerja ini tidak memberikan hak-hak kepada si korban, karena memang si korban tidak mengetahui. Nah, posisi korban tidak mengetahui ini di kami ini salah satu syarat bahwa korban berada di dalam posisi rentan yang dapat disalahgunakan. Kemudian nanti kami akan sampaikan beberapa praktek terbaik di kami dalam membuktikan persyaratan hal-hal persyaratan pembuktian ini. Kemudian yang kedua itu di kami perlu dibuktikan kerentanannya. Kerentanannya tadi beberapa yang disampaikan oleh pemateri sebelumnya, ada berbagai macam kerentanan, hampir sama. Di kami ada beberapa kerentanan tadi posisinya karena kemiskinan, karena memang sedang butuh uang untuk hidup, keadaan mendesak. Jadi si korban pekerjaan apa saja akan diambil, walaupun pekerjaan itu dia tahu dia akan menerima pembayaran tidak sesuai dengan ketentuan, dia akan menerima hak yang tidak sesuai dengan aturan yang ada di Indonesia, tapi tetap diambil karena dia posisinya sedang membutuhkan. Kemudian juga dalam keadaan bahwa korban ini tidak berpendidikan, pendidikannya rendah, sehingga apa yang diberikan oleh si pemberi kerja, korban mengiyakan, menyetujuinya karena ketidaktahuannya. Nah, ini posisi rentan juga di kami. Di dalam praktek persidangan banyak perkara-perkara, kasus-kasus yang seperti ini. Kemudian juga korban kekerasan dalam rumah tangga. Ini biasanya karena emosionalnya tidak stabil si korban. Ini bisa terjadi. Korban perkosaan juga karena emosionalnya tidak stabil. Kemudian secara fisik juga dia menjadi korban. Kemudian keadaan ini kemudian dimanfaatkan oleh para pelaku dalam mengambil kerja kepada si korban. Dan juga ada beberapa posisi kerentanan yang lain, masih banyak lagi. Kemudian persyaratan ketiga adalah di kami perlu dibuktikan adanya keuntungan. Keuntungan ini adalah keuntungan yang diterima oleh para pelaku, baik finansial maupun keuntungan lainnya. Karena keuntungan ini akan menggambarkan tujuan pelaku, keuntungan ini akan menggambarkan bentuk eksploitasi yang terjadi, dan keuntungan ini akan menggambarkan kalau di kami sistem teori pertanggungjawaban pidana itu seseorang dapat dikenakan pidana harus memenuhi dua unsur, harus ada actus reus, perbuatan pidana, dan harus ada niat jahat, niat batin. Nah, keuntungan ini menggambarkan salah satu dari niat batin atau niat jahat dari si pelaku. Nah, ini hal-hal persyaratan yang harus dibuktikan di dalam persidangan, dengan cara penyalahgunaan posisi rentan. Nah, di kami dalam beberapa praktek dengan modus cara penyalahgunaan posisi rentan, dapat saya sampaikan sedikit gambaran. Mohon diingatkan kalau waktu saya sudah habis. Yang pertama adalah mengenai perkara pengiriman tenaga kerja Indonesia untuk menjadi anak buah kapal ABK di Korea Selatan. Nah, ini menarik, perkara ini masih baru di tahun 2020, awal-awal pandemi, perkara ini. Jadi para tenaga kerja di Indonesia direkrut oleh agen perusahaan di Indonesia, yang agen ini dia merekrut, dia tidak punya izin untuk mengirim tenaga kerja ke luar negeri. Dia juga tidak punya perjanjian resmi, order untuk pekerjaan di Korea Selatan, di luar negeri, dengan agen di luar negeri, sehingga perolehan order itu di bawah tangan. Karena di ketentuan di kami bahwa order itu harus dilaporkan kepada atase negara Indonesia di negara yang bersangkutan. Tapi itu tidak dipenuhi. Kemudian juga si agen di Indonesia ini, mereka mengirimkan orang-orang sebagai tenaga kerja itu dengan kesepakatan pengambilan uang, keuntungan mereka itu rata-rata sebesar sampai dengan 30% dari jumlah penghasilan. Nah, seluruh yang terjadi dalam proses perekrutan itu sudah sesuai dengan apa yang disampaikan oleh pelaku. Artinya pelaku tidak melakukan penipuan. Pelaku tidak memberikan keterangan bohong kepada para korban. Namun pelaku tidak memenuhi hak-hak korban dalam hal tadi, perjanjian harus dilaporkan ke atas perwakilan Indonesia di Korea Selatan. Kemudian pelaku juga tidak mendaftarkan jaminan kesehatan dan segala macam. Kemudian singkat cerita, korban ini berangkat ke Korea Selatan, kemudian menjadi ABK di kapal asing. Di dalam kapal asing itu kemudian terjadi eksploitasi. Korban dieksploitasi, terdapat kekerasan fisik oleh pelaku yang di negara di luar, di Korea Selatan. Kemudian juga ada pemberian makanan yang tidak sepantasnya, sehingga beberapa korban meninggal dunia di kapal. Nah, perkara itu di Indonesia, terhadap pelaku di Indonesia itu dikenakan tindak pidana perdagangan orang dengan salah satu caranya adalah penyalahgunaan posisi rentan dari para korban. Nah, ini korbannya yang meninggal waktu itu cukup banyak, ada tiga orang, dan yang sakit ada hampir sekitar 18-an. Itu yang pertama. Yang kemudian yang kedua, perkara pengiriman tenaga kerja Indonesia untuk dipekerjakan di Timur Tengah, ini juga posisi rentannya hampir sama sebenarnya, karena memanfaatkan kurangnya pengetahuan para korban, karena tingkat pendidikannya rendah, para pelaku manfaatkan, juga ditambah kerentanan karena memang para korban membutuhkan pekerjaan, sehingga dikirimkan secara perorangan. Ketika dikirimkan secara perorangan, banyak hak-haknya korban yang tidak dipenuhi, sehingga pada saat korban bekerja di luar negeri, korban tidak mendapatkan haknya. Nah, ketika korban melapor, pelaku di Indonesia dikenakan TPPO dengan salah satu modusnya, cara melakukannya adalah mempergunakan posisi rentan. Memang dalam beberapa kasus lain juga penyalahgunaan posisi rentan ini juga diikuti oleh cara-cara yang lain, seperti adanya kekerasan terhadap pelaku yang sama, terhadap terdakwa yang sama orangnya. Terdapat unsur cara yang lain seperti kekerasan atau ancaman kekerasan atau penipuan atau pemberian manfaat pembayaran. Itu ada disertai dengan cara-cara seperti itu. Kemudian ada juga prostitusi dengan korban warga negara asing di salah satu wilayah di kami di Cianjur, Jawa Barat, ini korbannya memang warga negara asing yang sedang membutuhkan uang untuk bertahan hidup. Jadi dia kemudian dipertemukan oleh pelaku kemudian menawarkan korban untuk dijual untuk berhubungan badan dengan pembagian keuntungan. Pelaku mendapatkan 15%, 85% korban menyetujuinya. Jadi segala cara yang ada di tindak pidana perdagangan orang itu tidak terpenuhi, hanya posisi rentan dari si korban yang membutuhkan uang, yang kemudian pelaku memanfaatkannya sehingga terjadi sebuah transaksi penjualan tubuh, penjualan prostitusi, dan kemudian pelaku bisa ditangkap. Ini salah satu contoh juga kasus yang ada di Indonesia. Dan ada beberapa kasus lain dengan modus yang berbeda. Mengingat waktu, ada satu hal yang menarik di hukum kami.
Oke.
Ya, mengenai pembuktian terhadap perkara TPPO
Yes,
dengan
please.
modus sedikit dengan modus prostitusi, karena bahwa cara sebagaimana unsur kedua di dalam TPPO tidak ditemukan, hanya posisi rentan yang ditemukan itu juga versinya penyidik kepolisian, karena ini bukan berasal dari laporan laporan korban, tapi berasal dari laporan temuan pihak kepolisian. Nah, rupanya di dalam proses penyidikan maupun di persidangan, korban tidak merasa sebagai korban TPPO. Korban tidak melapor ke pihak berwenang. Korban merasa tidak memiliki kerugian baik material maupun material. Korban tidak berani mengatakan bahwa dirinya menjadi korban, dikarenakan pelaku merupakan jaringan kriminal terorganisir. Korban juga tidak menuntut ganti kerugian. Nah, ini menarik di kami di Indonesia ketika ada perkara seperti ini. Karena beberapa perkara, bukan cuma satu perkara seperti ini, ada beberapa. Pada perkara yang lebih dahulu disidangkan di kami, perkara seperti ini aparat penegak hukum dari penyidik, penuntut umum termasuk hakim ketika di persidangan ini sependapat bahwa perkara ini bisa dibuktikan didakwakan dengan TPPO, sehingga terbukti dengan TPPO. Namun ada perkara pada waktu yang berbeda, ternyata perkara ini bukan TPPO. Perkara ini dianggap adalah perkara pencabulan, menyelenggarakan pencabulan. Nah, ini yang menarik. Saya tidak tahu di
Pak
negara
Agustri,
lain.
I
Siap.
might have to cut you there. Thank
Oke,
you
terima
so
kasih. Mungkin
much.
seperti itu.
All right, thank you so much. You have
Ya,
given us
terima kasih.
terima kasih. You have given us so much examples, and it's very much appreciated, and especially for emphasizing the difference in position and power between a trafficker and a victim. All right, and our last but certainly not the least speaker, calling in from London, UK, Honorable Pamela Bowen, Commander of the Order of the British Empire, is Senior Policy Lead of the Crown Prosecution Service for Human Trafficking and Organized Immigration Crime since 2016. She was responsible for developing the first policy in the UK on the non-prosecution of victims of trafficking who have been committed criminal offenses in 2007 and for its constant evolution. She has worked with international organizations, ministers, and criminal justice authorities in many source and transit countries in negotiating and developing improved and collaborative responses to human trafficking. She has been a regular contributor to the development, she has been a regular contributor to the development of European and international policy and guidance since 2009. Pam has contributed to many expert groups' concept papers to assist other jurisdictions and most recently on development of international model law. She was one of the 5 experts in developing online training on criminal and civil litigation for human trafficking for the Council of Europe. She has contributed to Human Trafficking Handbook to assist legal practitioners. So Pam will also share her expertise and knowledge in prosecuting human trafficking cases that involves abuse of position of vulnerability. Honorable Pam, the floor is yours.
Right. Good morning, and thank you so much for that lovely introduction. And my apologies for being a little bit late. So good morning, good afternoon, or good evening, everybody. Now, I've been working on human trafficking now for over 15 years. And one of the greatest challenges for investigators and prosecutors is victims. Their identification, many don't realize that they are victims and they don't report to law enforcement, but they may not be able to escape their situation to report. They may be in fear, or the vulnerabilities are likely to be a barrier. And those vulnerabilities include the fact that they may have learning difficulties, they have mental or physical disabilities, language barriers, irregular immigration status, or a previous criminal record. So in the UK at the moment, we have a problem with trafficking for criminal exploitation. Therefore, victim participation where they themselves have committed crimes is very difficult. Investigations rely on the evidence of harm to victims rather than the defendant's motives. Our legislation is also clear that the consent or otherwise of the victim is irrelevant to prove a trafficking allegation. So consent does not mean a lack of exploitation. And it's not for the prosecutor to formally identify the victim, even if they are not formally identified through the national referral mechanism. That doesn't affect our ability to prosecute. We rely on all of the evidence, regardless of whether the person has been formally identified or not. And that evidence comes from multiple different sources, as we will see. So what is vital is to build strong cases with independent evidence. It enables prosecutions where victims' testimony can be chaotic or challenging, or we anticipate the defense will seek to undermine them. The best approach is to front load investigations, build intelligence and evidence before making arrests. And it also enables us in some cases to bring prosecutions without the victim at all. So prosecutors work closely with investigators to build robust cases right from the outset. We also consider victim strategies, that is, who should be treated as a victim and who should face criminal charges. So some significant investigations with multiple people involved often result in victims, alpha victims, and defendants operating at all different levels. So we have to consider who we're going to prosecute and who we're going to use as to give evidence. But we also have to consider at this stage the victim's support needs. So our law is clear that the consent of the victim is irrelevant to prove a trafficking allegation. No one can consent to their exploitation, even though they may have consented at the beginning. So we prosecuted a case of human trafficking for sexual exploitation, where the victims had all worked previously in prostitution in Thailand. The judge raised his concerns that if they had previously worked in prostitution, then how could we prosecute for trafficking? We argued that despite their previous history, the defendants were abusing and exploiting the women who were paid very little, and they had no say as to what services they were told to provide. And the defendants were making significant profits from them. The judge agreed we could prosecute for trafficking, and the fact that they were previously prostitutes would go to the issue of sentencing. So the defense was obviously consent, but even though the victims had consented to travel and to work here, they did not consent to their exploitation. The traffickers were convicted and all their profits were confiscated. It's also important right from the outset to consider case presentation at court. And that includes impactful evidence and visual evidence that will corroborate what the victim says. So nothing tells a story greater than images or film, and it helps the court to understand the circumstances. So when gathering evidence, we have to also think ahead about the trial at court. So in the UK, the police wear body-worn video cameras, and they record whatever they encounter so that they can capture on film the place where the victim has been exploited in work, how they live, often in squalid accommodation and sometimes beneath human dignity, any injuries that they have. Many of them are suffering from malnutrition, from lack of food, and clothing. They're wearing very raggedy and poor clothing. These are all important to sort of demonstrate the vulnerability of the victim, but also how the defendant has abused it. So in a recent case, the male victims of forced labor were so hungry, we had evidence from witnesses who saw them foraging in bins for food. And the police managed to get some CCTV evidence of that. But it's also important to show how the perpetrator lives. So images of the more luxurious accommodation, maybe expensive cars, money spent on luxury holidays. So this also underlines the importance of financial investigation to show how much money the trafficker has. But we also consider use of experts in determining vulnerability. We have quite strict rules about use of experts in the UK, but we can call experts where whatever they're going to be talking about is outside of the ordinary everyday experiences of a jury. Experts can be used to explain cultural differences or the effects of psychological control. So, for example, medical evidence we can bring to show mental disability and how that manifests itself where the victim is controlled by someone. We also have a procedure in the UK called ground rules hearings. So before the trial starts, we can make an application to the judge to set ground rules on how the victim should be questioned. And because many victims cannot respond to lengthy or leading questions, and the judge will often want to hear from an expert, perhaps an intermediary, who has made an assessment of how the victim can best answer the questions that are asked of them. And then the judge will set out then rules on how the victim should be questioned. So we had a recent case of a very vulnerable man who was kept in a shed for 40 years in slavery and forced labor. He had very poor language and learning difficulties. He claimed his traffickers, though, were very good people who gave him accommodation and food, and he appeared to consent to his situation. However, he needed an intermediary to enable him to communicate properly, having been kept in a shed for 40 years. As I say, his language skills were very, very underdeveloped. So we asked the judge to set ground rules about how he should be questioned, and he was also allowed to give his evidence and cross-examination through video evidence. So in advance, the intermediary reviewed how the questions from both the prosecutor and the defense advocate were going to be asked, and she broke them down into short, simple, straightforward questions that he could understand. Anyway, that worked really successfully, and he was able to give strong evidence which convicted the defendants. So we're also aiming now to prosecute more cases without relying on the victim. So as long as independent evidence will prove all of the elements of an offence, we can do this. So in the UK, the move to recruitment and to exploit victims through digital devices now provides us with challenges, but also opportunities through an independent evidence trail. So in cases of sexual exploitation, we work often now with adult services websites to obtain evidence, and the police use what we call data wash tools to identify potential victims on websites. And we have agreements with these websites that they provide us with email addresses, mobile numbers, and credit card details so that we can trace the trafficker. Because in order to actually advertise their victims, the defendants have got to provide all those details to the websites. So using the information from bank details we can get from these online websites, we can also evidence things like flight tickets, paying for accommodation, banking evidence showing money flows. Then law enforcement can also use covert surveillance, CCTV evidence, and seize material from crime scenes such as money, personal computers, vehicles, mobile phones belonging to both suspects and victims, and any identity documents which are being withheld. So we can then prosecute these cases showing the relevance and links to them all, and showing that the defendants are actually recruiting and exploiting victims, earning a lot of money from them, but without actually ever obtaining the testimony or evidence of the victims. So one such case, which also highlights the importance of ensuring that the public are aware of what's going on, involved a trafficker who used his local library to make all the arrangements for trafficking women into sexual exploitation using adult websites on the library computer. The librarians are very suspicious, as he also had about 8 mobile phones with him. So each time he came in once a week, they kept surveillance and they recorded what he was doing and eventually reported it to the police. So the library computer and the seized 8 telephones from the trafficker all provided the evidence needed to convict him without any victim's testimony. So a leading barrister who prosecutes many cases of trafficking always uses this English phrase about vulnerability and consent as introducing the victim, warts and all, which means showing their imperfections and faults. Don't attempt to hide them, because those faults are also their vulnerabilities and makes them a target for exploitation. One such case example that we prosecuted recently involved 200 victims who were recruited as they were leaving prison in Poland. They were without jobs or money, some had mental health issues, but all had consented to their recruitment for work. Knowing that they had a criminal record ensured that they would not report to the police. They were held in forced labour in the UK, none were paid. We selected over 80 to provide testimony. And in opening the case to the court, the victims were introduced as vulnerable men with many previous convictions and learning difficulties, mental health issues, no jobs or money. And the defence tactics then in undermining them because of their previous criminal records were already out there. So we were able to show the abuse of their vulnerability by the traffickers by targeting them, which vitiated their consent. It was also important for law enforcement to reassure them that they were not investigating them because of their criminal records, but because they were victims. So very briefly in conclusion, victims cannot consent to their own exploitation. Building cases with independent evidence is vital. Emphasize and show the vulnerabilities of your victim at court. Those vulnerabilities make them a target for traffickers and those who abuse their vulnerabilities. So what we call warts and all. Use expert evidence where you can and consider maximum support measures that you can put in place to assist the victims giving their evidence. And finally, ensuring that you raise the profile among the public, because as we've seen from the case involving the librarians, they also make very good investigators. So thank you very much indeed. That's the end of my presentation. Thank you.
Thank you very much, Honorable Pam, for that insightful presentation on victims' vulnerabilities and, of course, the value of building strong cases with independent evidence. I think one very clear highlight for me is the removal from the victim the burden of proving the tip case, and this will also prevent them from possible re-traumatization. All right, on to our next session. I see that there are already many questions coming in. Our next session will involve 3 parts. We have the poll results, and the 2 videos that will be shown, 2 prosecutors from Thailand and the Philippines, and then we'll open the floor for question and answer. But please feel free to type in your questions. I see some raising hands, but we would encourage you to type in your questions so that our speakers who can actually directly answer the questions if they're comfortable, as they can also see your questions in the Q&A box. All right, now let us go back to the poll questions and the results and allow us to actually look at the results. So on the first question, based on your understanding, which term most relates to vulnerability? And it would appear that 40% said that it's that weakness relates most to vulnerability, followed by lack of choice at 31%, and then 29% that it is beyond one's control. So weakness is at 40%. And then on our second question, in your view, what action should be prioritized to improve justice response in recognizing and proving vulnerability in court? And we can see that 53% says that clear policy guidelines on vulnerability and victim protection is a good response, and then followed by 26% on research on vulnerability factors and successful prosecution and good practices, and then a 21% tip training on vulnerability and evidence needed. Now, may we hear from our speakers, no? The reaction to the poll results. May I invite Justice Adele and Dr. Marika to share their reaction to the first poll question and results.
Should I start?
Yes, please, Justice.
Good morning again. As we can see from the poll, weakness, lack of choice, of course, in my perspective, weakness is a trigger to the lack of choice. If you are weak, you will be susceptible to abuse. You have no choice. And this proves a principle that we have reached while we were doing the issue paper with Dr. Marika on vulnerability. Weakness would pose and put the victim in a position where she or he has no real and acceptable alternative but to submit to the abuse involved. This is clear. So weakness and lack of a choice are interrelated. Thank you.
Thank you very much, Justice Adele. Dr. Marika, please.
Thanks, Darlene. Look, I think they're interesting responses because they all intersect, as Judge Adele says. But I think crucially, from a response point of view, we need to ask ourselves, why is a person weak? Why do they lack choices? Why are things outside of their control? And I think it's time that we start reminding ourselves that states are the duty bearers in preventing trafficking in persons. So we need to really have some candid and courageous conversations about how states create weakness, how states create lack of choice, how states place circumstances beyond victims' control. And in both origin and in destination countries, I think that looks like looking at human rights violations, gender inequality, structural discrimination, things that create these circumstances of vulnerability, as well as, of course, looking at migration and border policies and indeed labor policies that entrench this vulnerability. So, in short, states are the duty bearers of so much of this. So to the extent that these things are in their control, we need to ask how it is that they are manufacturing these vulnerability factors and what they can do to stop doing that. Thanks very much.
Thank you so much, Dr. Marika. And of course, those are all very good points as far as these are concerned. So I'm glad that we got these results and for us to be able to, share more about vulnerability and the connection of the weakness, lack of choice, and beyond one's control. Now, let us go to our two other panelists to comment or give their reaction on the second question and its results. May I call on Honorable Pam, then followed by Pa Agustri to give their reaction.
Thank you, Darlene. My personal sort of priority is sort of for all of those, and I think particularly training on vulnerability, identification of it, and evidence needed, because unless you understand that the vulnerabilities that victims have, it's very difficult then to assess sort of the extent to which that is being abused. And I think sort of understanding that helps us to collect evidence to actually present at court. And I think, also clear policy guidance on vulnerabilities and victims is very important in terms of ensuring that everybody is aware of how sort of the vulnerability factors sort of play into the whole sort of abuse of power and vulnerability between victims and defendants. Thank you.
Thank you so much, Pam. And may we hear also from Pa Agustri and his thoughts on looking at the clear policy guidance being the highest from our participants.
Ya, terima kasih. Dari beberapa jawaban tadi sangat baik sekali. Tapi ada hal yang menjadi penekanan saya ketika berbicara mengenai kerentanan, penyalahgunaan posisi rentan ketika kita berbicara unsur elemen kedua pada TPPO. Bahwa yang pertama memang saya pikir perlu ada definisi yang sama, definisi dan penafsiran yang sama mengenai posisi rentan dan penyalahgunaan kerentanan. Mengingat TPPO ini adalah kejahatan transnasional yang bukan hanya pada satu negara, tapi juga terjadi dan melibatkan negara-negara lain yang saling berhubungan. Itu penting sekali faktor definisi yang sama, karena ketika sudah ada definisi yang sama, penafsiran yang sama, nantinya masing-masing negara juga bisa merumuskan melalui perangkat perundang-undangannya terkait dengan undang-undang pidananya, khususnya hukum acara pidana yang terkait dengan hal itu. Khususnya lagi adalah mengenai pembuktian. Bagaimana kira-kira di dalam proses persidangan pembuktian apa yang paling penting, yang menjadi prioritas kita bisa bawa di persidangan untuk kasus TPPO dengan modus penyalahgunaan posisi rentan. Nah, menurut saya ini menjadi hal yang penting. Terima kasih.
Thank you so much, Pa Agustri. And yes, these are all very important justice responses. And thank you again for all of both of you and Pam's comments on this. Now, let us play two videos, as I've mentioned. We invited two prosecutors to share or to answer a question, a very specific question. What was the challenge encountered on proving the abuse of position of vulnerability as a second element in prosecuting trafficking in persons cases? So we will play the video from Thailand prosecutor, and followed by the video from the Philippine prosecutor. And then again, we'll ask everyone to give their reaction on the video.
Okay. อะไรคือความท้าทายในการที่จะนำสืบพิสูจน์การล่วงละเมิดความเปราะบางของผู้เสียหายซึ่งเป็นเรื่องที่ยากเนื่องจากจะแตกต่างจากในเรื่องของการนำสืบในเรื่องของการบังคับการหลอกลวงเพราะเป็นสิ่งที่จับต้องได้ทำอย่างไรที่จะทำให้ผู้เสียหายเกิดความมั่นใจว่าพยานหลักฐานต่างๆเนี่ยได้มาจากเจ้าหน้าที่ของรัฐเป็นผู้แสวงหาไม่ใช่ได้มาหรืออาศัยแต่เพียงลำพังคำเบิกความของผู้เสียหายเท่านั้นยันความท้าทายจะมีอยู่หลายประการดังต่อไปนี้ประการแรก forensic evidence พยานหลักฐานทางนิติวิทยาศาสตร์ที่จะทำให้ผู้เสียหายเกิดความมั่นใจว่าเจ้าหน้าที่ของรัฐได้รวบรวมพยานหลักฐานอย่างเพียงพอแล้วที่จะดำเนินคดีกับผู้กระทำความผิดได้เพื่อให้ผู้เสียหายให้การยืนยันในข้อเท็จจริงบางประการประการที่2การที่มีความเห็นของผู้เชี่ยวชาญอยู่ในสำนวนการสอบสวนคดีค้ามนุษย์ตั้งแต่แรกในการที่จะนำสืบในเรื่องของความเปราะบางควรที่จะมีตรรกะควรที่จะมีเหตุผลทางวิชาการเช่นในเรื่องของระดับ IQ ของผู้เสียหายที่ผิดปกติจากบุคคลทั่วไปในเรื่องของความล้มเหลวของครอบครัวหรือในเรื่องของความเสี่ยงต่อโรคภัยที่ผู้เสียหายอาจจะได้รับในอนาคตจากการที่ให้บริการทางเพศหรือการที่ทำแรงงานในลักษณะของการทารุณโหดร้ายประการที่3ความเข้มแข็งของระบบการคุ้มครองพยานเพื่อให้ผู้เสียหายเกิดความมั่นใจว่าเมื่อผู้เสียหายให้ข้อเท็จจริงหรือให้ข้อมูลแล้วผู้เสียหายและครอบครัวจะได้รับความปลอดภัยประการสุดท้ายถ้าหากพนักงานอัยการพนักงานสอบสวนและเจ้าหน้าที่ของรัฐสามารถที่จะนำพยานหลักฐานที่เกี่ยวกับความเปราะบางมานำสืบให้เห็นศาลก็จะสามารถที่จะวิเคราะห์ได้ว่าเหตุใดผู้เสียหายถึงให้การกลับไปกลับมาเหตุใดผู้เสียหายถึงเกิดความรู้สึกชื่นชมในตัวผู้กระทำความผิดเหตุใดผู้เสียหายถึงไม่หลบหนีซึ่งเหล่านี้จะทำให้สามารถที่จะวิเคราะห์ลักษณะของคดีค้ามนุษย์ได้มีประสิทธิภาพยิ่งขึ้น
The behavior of the trafficking victim is often difficult for third persons to understand. Likewise, The victim would also have difficulty in comprehending what has happened to him or her and explaining or discussing the same to other people. In prosecuting trafficking in persons cases, the challenging part in proving the element of taking advantage of the vulnerability of the person is when the victim withholds information as to the facts and circumstances of the trafficking incident or would change his or her story about how he or she was trafficked. As a result of which, the report prepared by the social worker or the psychologist would then have variances. The defense would then point to these inconsistencies in the report and say that the victim is not credible or that the report prepared by the social worker or the psychologist is biased. Thus, to counter this defense raised by the defense, I would often recall the social worker and or the psychologist to the witness stand to explain such variances.
All right. May we call on or invite Honorable Pam and Marika to share their thoughts on the video from the Thailand prosecutor.
Oh, hello, Darlene. My thoughts on the first film and the prosecutors the film of the prosecutor, and her. I think she mentioned a really important point, which is why victims don't escape from don't try to escape from their situations. And I think sort of people anticipate that they will victims will be either locked up or threatened or abused, or sort of they've got nowhere to go. But we often have a sort of a saying in the UK that they have psychological chains, which where their will to actually leave, and their reliance on the trafficker for food, accommodation, and everything else is so great that they, however bad it is, they are unable to actually leave their situation. And I think sort of we can emphasize that by use of both experts as and when they are admissible at court, but also I think the building up a picture of the victim situation and showing the sharp contrast as well between how the victim is actually living and the circumstances compared to how the trafficker is actually living in their circumstances. Thank you.
Thank you so much, Pam. May we hear from Marika?
Yeah, I found those videos really interesting. I think prosecutor Ratananakin really explains well how victim behavior and beliefs can be detrimental to trafficking cases. And I think this points again to this challenge we face, not just in ASEAN, but globally, of over-reliance on victim testimony, which really heavily burdens them. And that to me points to a need to increase capacity to use alternative evidence, to build capacity on special investigative techniques. And I love Pam's example of the librarians as a really strong example of where victims have been spared from those testimonies. Also, I think I have to emphasize that that great video really emphasizes that the power of expert insights to explain victim behavior, but also the need to understand that victim protection is crucial to trafficker prosecution. And I think we need to remind ourselves again that we're trying to prove abuse of a position of vulnerability, and that in the hands of a skilled prosecutor, I think even when a victim is insisting that they're not a victim and they're insisting that the trafficker is not a bad person, a skilled prosecutor can say, see, they're so much under the influence of the trafficker that even with all this exploitation, they are still insisting that this was all okay. But I guess the point that I'd like to underline is that we are trying to evidence the actions and intentions of perpetrators, not victims. And we have to only consider what victims are saying and believing and experiencing to the extent that that offers insight into criminal conduct and culpability of traffickers, because victims are not on trial.
All right. Thank you so much for those insightful reaction. Now we ask Justice Adele, invite Justice Adele and Pa Agustri to give their reaction to the Philippine video prosecutor.
Oke, terima kasih. Baik sekali ya apa yang disampaikan dalam dua video tadi. Memang ketika menangani perkara TPPO, korban memiliki keterangan yang sangat penting buat alat bukti keterangan saksi korban sampai dengan pada tingkatan persidangan. Bahwa korban itu adalah memang korban yang mengalami penderitaan fisik, mental, fisik, seksual, ekonomi, dan atau sosial yang diakibatkan oleh tindak pidana perdagangan orang yang dilakukan oleh para pelaku. Namun yang lebih penting lagi sebenarnya ketika berbicara unsur cara penyalahgunaan posisi rentan, dalam sudut pandang kami di Indonesia ketika melihat praktek, apa yang saya sampaikan tadi di paparan, yang pertama kami akan melihat itu adalah keadaan yang tidak seimbang dulu antara pelaku dengan korban, terutama ketika para pelaku dan korban ini terlibat dalam hubungan pekerjaan, pemberi kerja dan penerima kerjaan. Itu ada keadaan ketidakseimbangan. Kemudian kita juga bisa yang selanjutnya itu harus bisa merumuskan keadaan korban yang merupakan kerentanan ini apa. Tadi banyak ya, kita sama-sama membicarakan dari seluruh pemateri juga kemiskinan, pengetahuan yang rendah, dan lain sebagainya. Kemudian juga kita juga harus bisa merumuskan unsur kesengajaan dari perbuatan yang dilakukan oleh pelaku, terutama ketika dia melakukan perbuatan dan pelaku ini mendapatkan keuntungan. Nah, ketika pelaku mendapatkan keuntungan berarti eksploitasi sudah terjadi atau eksploitasi bagiannya sudah terjadi sebagian. Nah, tinggal eksploitasi di akhir. Nah, tiga hal ini sudah terpenuhi, kita kemudian akan berbicara elemen lain dalam unsur TPPO, proses tindakan dan eksploitasi sudah oke. Saya pikir dari pengalaman praktek yang terjadi di Indonesia, modus cara penyalahgunaan kerentanan ketika si korban juga keterangannya tidak bagus buat pembuktian, nilai pembuktiannya rendah, dalam beberapa penanganan perkara ini bisa dibuktikan dengan baik. Itu yang terpenting. Dan yang paling terpenting lagi adalah ketika kita penuntut umum merumuskan ketidakseimbangan itu juga harus aparat penegak hukum yang menangani baik penyidik maupun penuntut umum menggambarkan bagaimana ketidakseimbangan itu antara yang terjadi dengan peraturan perundang-undangan yang berlaku. Kalau bicara tentang tenaga kerja, ya peraturan perundang-undangan tenaga kerja. Hak dan kewajibannya apa? Ketika tidak sesuai itu sudah terjadi ketidakseimbangan. Ketika berbicara pekerjaan freelance yang tidak ada kontraknya, apa seharusnya yang dibutuhkan dan modus-modus lain. Mungkin seperti itu dari saya. Terima kasih.
All right, thank you so much. May we call on Justice Adele to also give his reaction to the two videos?
Yes, of course. As a matter of fact, I will make it very short to leave some time for the question and answer because I can see that there are very important questions. I will focus also on the position of the Court of Cassation on these issues. Firstly, I have to address the issue of fear of the victim. I think this is a very important task of the investigators and prosecutors to give a surrounding suitable environment to the victim to gain her cooperation. As we mentioned before, psychologists may be needed and required in these situations. However, just to go back to the case law and the principles established by the Supreme Court in Egypt, our court, in Egypt, we can establish an above case in trafficking in persons without the testimony of the victim. Without the testimony of the victim, we can still establish a case by the testimonies of the police officers who caught the crime, by other evidence, circumstantial evidence, we can still establish a trafficking in human person case without the testimony of the victim. And the issue of changing the testimony, the victim maybe during investigation say something when she is called before the court, she will say another story. And we have experienced this. For example, the victim would say that the perpetrators took me to a store and abused me. In another story before the court, she will say that the victims took me to a house and they abused me. For the court, the Egyptian courts, the Court of Cassation, the principle that the rule is this, it is irrelevant for the victim to say that she was abused either in the store or in a house, because what we care about is the elements of the crimes. Are the elements of the crime have been established without these variances? Yes, it is established. The also of inconsistencies, this is the same approach also. The Court of Cassation say that the judge can deduct the real actual situation and the circumstances, even if the witnesses, there were inconsistency in their testimonies. And I will stop on this. Thank you.
Right.
Thank you.
Thank you so much, Justice Adele. And now that we've done with the presentation and then of course the polls and the videos, I think very common in the discussion is that we really have to consider the whole picture, the vulnerabilities of the victims, the circumstances that contribute to those vulnerabilities from the onset to the time that they're in the criminal justice process, and for the justice officials or state actors to be very sensitive to the needs of the victims and to protect them from further harm. So now I know we're very much over time, but we would still like to take on a few questions if our speakers and our participants are amenable to extension of a few minutes just to address some of the few questions. I know we will not be able to address all of the questions. And I'm glad that some of you have already addressed those questions directly in the box, chat box or Q&A box. So I'll give the floor to Kem to facilitate the Q&A for a few minutes before we close the program.
Thank you so much, Darlene. Yes, just to take off the pressure from Darlene for a few minutes, but not take off the pressure from our distinguished panelists. I'll first ask Justice Adele the first question, because Justice Adele was the last one who reacted to the videos. Justice Adele, here's one of the beautiful questions our participants ask in the Q&A box. In case of studying the roles of investigators, as you earlier recommended, prosecutors, judges, and courts, you think the roles of families, social workers are also equally important?
I have already taken a snap shot of the question, because it is already important, a very important question that I can see. I would like firstly to mention something that I didn't, of course, touch upon the issues of family and social workers and welfare workers, because it falls outside of the content and the purpose of this webinar, which is criminal justice actors. So this is why my focus are on prosecutors or judges, for example. But I can agree with Wilma. I can agree very much with Wilma that, of course, other surroundings like family, social work officers are very crucial and important in their role to prevent vulnerability. And sometimes families can pose vulnerabilities when the family impose situations of poverty and on the victim and their daughter. We are poor, we need money, and you have to do something to send your brothers to education. You have no other, she has no other choice but to go to the streets, for example, for prostitution to gain money. So in this case, the families are posing the vulnerability conditions, for example. And social workers, welfare officers are very important, of course, to release the pain, to release the vulnerability, and to encourage the victim to testify about everything what happened. So I agree with Wilma that other actors are very important in above TIP cases, of course. Thank you.
Thank you so much, Justice Adele. Now that we are realizing really trafficking in persons is a complicated issue, and one of the messages I think are coming out from this webinar. Now, let me ask Dr. Marika McAdam. I'm asking from the order that I see you in my screen. So Marika, can you perhaps answer this question that based on one of the comments of the panelists, states play a vital role why traffic victims become weak and lacking of options? Should states be held liable to give financial assistance to victims so that they can be more active in eradicating the crime? So it sounds like disincentivizing inaction of states. Marika, please.
It's a very interesting question, Kem, and I thank the person who asked it. I mean, I think there's two elements there. I think states are responsible for so much of the vulnerability at the outset, but then once a person becomes a victim, they of course have a whole host of other obligations to that person, not just financial, but in other respects as well. So I think that I think it's incumbent upon us to remember that all of the international frameworks, all of the regional frameworks, including in ASEAN, speak to the responsibilities of states. Some of that is absolutely financial, but when a person becomes a victim of trafficking, a group of obligations is owing to them. But prior to that, there are strong obligations to prevent the vulnerability of people becoming victims in the first place. And I think we would all agree that in the international and regional frameworks that we are all working with, the least implemented of them all are those prevention obligations.
Thank you so much, Marika. And speaking of prevention, I think there is an active debate and sharing of insights over the chat box. So I will invite our participants also to check the chat box. You will also be able to see what other participants are thinking. And now I'll go to Indonesia. Pak Agustri, I think this question is for you. It was typed in Bahasa Indonesia, but I'm going to, I asked an online translator to translate this into English. So basically the question is, can you please tell us of an example or a practice in Indonesia where you can better execute the restitution for victims of trafficking as ordered by courts?
Iya, pertanyaan yang baik sekali. Ketika berbicara restitusi, ganti kerugian, saya masih mengambil contoh perkara yang memang unsur caranya adalah penyalahgunaan posisi rentan, kerentanan. Dalam perkara pengiriman ABK, tenaga kerja Indonesia menjadi anak buah kapal ke Korea, itu yang disidangkan di Pengadilan Negeri di Brebes, itu adalah salah satu contoh penerapan restitusi yang baik di dalam perkara di Indonesia, karena terdakwa yang kemudian setelah diputus menjadi terpidana itu atas kesepakatan bersama di persidangan, pembicaraan di depan persidangan, terdakwa itu mau membayar restitusi dan kemudian setelah putus memberikan restitusi atas jumlah yang disepakati di depan persidangan. Nah, dalam praktek penerapan hukum di Indonesia ini salah satu contoh pelaksanaan penerapan ganti kerugian yang baik, karena pertama terpidana mau membayar, yang kedua jumlahnya adalah atas kesepakatan bersama di persidangan yang merupakan bagian dari proses persidangan yang terjadi. Mungkin itu contoh yang terjadi. Terima kasih.
Thank you so much, Pa Agustri. I think wonderful sharing of experience over there in Indonesia. And now for the final question, I'm afraid we won't be able to tackle all the questions this afternoon, but for the final question, Pam, this is specifically for you. On the medical examination of victims, shall we also include mental or psychological state resulting from traumatic experience, I think, as a factor in proving the vulnerability of victims? Pam, please.
Yes, of course, and definitely. Sometimes the vulnerability which involves the either psychological trauma or the physical trauma to victims can be pre-existing, which means that because they have those vulnerabilities beforehand, they then become easy targets for traffickers. Or they could actually develop those sort of traumas or disabilities as a result of their trafficking. So if they've been kept in sort of forced labor without any medical attention, and sort of the trauma that develops because of that, it's so important, I think, to show before the court. So definitely sort of medical experts, I think, are vital in showing how vulnerabilities have been either pre-existing or that have arisen or developed as a result of the trauma experienced through their trafficking. So I think they play a very important role. Thank you.
Thank you so much. I think above all, there needs to be a holistic approach to these cases in many other issues surrounding trafficking in persons, and even so in APOV. Unfortunately, dear participants, you won't be able to address all the questions that you have posed to our distinguished panelists. So now I am forced to give back the floor to our moderator, Darlene. Darlene, please.
Thank you very much, Kim. I know that you still want to read more questions, and that's what our participants would want to, but unfortunately, we're really running out of time. So thank you to the participants for your very well thought questions. But before we close this session with our esteemed panelists, may I again invite our experts to share any last message to all of our attendees in this room. So maybe we can start. I see Justice Adele to my right on the screen. So Justice Adele, please.
Yes, as I mentioned before, I am very pleased that this was a very interesting experience for me to see that both common law and civil law system are converging. We have similar rules when it comes to TIP cases in general. And for this reason, I will reiterate my request to you, Darlene, especially to you, and my request is focusing on you, consider the issue of having this pamphlet or booklet about the role of all actors in criminal justice in above TIP cases. And I think Honorable Pawan, she gave us some good thoughts in her presentation that will help to establish and improve this booklet or pamphlet. Thank you.
Thank you, Justice Adele. Very well noted on that recommendation. And now, since you've mentioned Honorable Pam, I'll give the floor to you.
Thank you. And thank you so much for inviting me here today. It has been so interesting. And I think particularly the questions that have been posed by the participants and their remarks. So I was going to say, in conclusion, I wanted to emphasize again that we need to show the vulnerabilities of your victim at court. Because it makes them a target for traffickers, and in many cases sort of proves the case sort of beyond anything else, but also the need to have independent evidence so that the full burden of actually proving the case doesn't fall upon the very sort of vulnerable victims who who are fearful of giving evidence and may not be able to give their best evidence because of those vulnerabilities. So my last sort of remarks are about building a strong case without the victim themselves. to reduce the burden on them, or indeed to actually have a trial without the victim at all. Thank you.
All right. Thank you so much, Pam. Very well noted as well on those points, 3 points that you've mentioned on vulnerabilities, independent evidence, and of course, building very strong case. So, and maybe call on Pa Agustri for her last thoughts.
Ya, terima kasih. Acara ini sangat baik sekali, terutama buat para praktisi, aparat penegak hukum terkait dengan penanganan TPPO. Banyak contoh-contoh praktek-praktek terbaik yang disampaikan para pemateri, para narasumber, yang memang penting sekali menjadi bahan juga, bahan bekal di dalam penanganan perkara, yang memang ternyata ketika perkara TPPO dengan modus penyalahgunaan kerentanan ini sangat membutuhkan kejelian dari penyidik dan penuntut umum dan jaksa penuntut umum dalam merumuskan bagaimana sebuah kerentanan itu terjadi. Alat buktinya apa saja? Pendapat ahli adalah salah satu hal penting yang bisa mendukung ini, dan kemudian juga alat-alat bukti di lapangan tergantung dengan modus operandinya. Nah, ini menjadi catatan sangat penting sekali karena memang banyak korban dengan korban TPPO dengan modus kerentanan ini, korban yang tidak memberikan keterangan yang baik buat nilai pembuktian di persidangan. Saya sepakat, kita semangat semua bahwa korban ketika tidak memberikan keterangan yang baik buat nilai pembuktian karena banyak hal, faktor ancaman, faktor ketidakpengetahuan, dan lain sebagainya, tetapi itu tidak menjadi kendala buat kita para penegak hukum untuk tetap membuktikan perkara TPPO dengan modus kerentanan, dengan penyalahgunaan kerentanan. Oke, seperti itu. Terima kasih.
Thank you so much, Pa Agustri. No, very well noted as well on the giving up of the careful attention, and of course the be mindful of the sensitivities around this concept and dealing with victims of trafficking. All right, and to say the best for last, we have Dr. Marika McAdam. Your thoughts, please.
That's kind, darling, but I've barely been left anything to say after those 3 comments from my colleagues. Look, you stole my final point, I think, which is going to be that we really need to work harder to reduce burden on victim testimony, but perhaps to end on a more controversial point that we didn't really get into in our discussions. You know, vulnerability is a complex phenomenon, as is trafficking, and we can agree that around the world, prosecutions remain dismally low, and I think we need to always ask ourselves, are we prosecuting the right people? And in those situations, for instance, where victims become traffickers themselves, and when we also know that traffickers may come from similarly vulnerable situations as victims. So I think then it's a reminder to us to take victim-centered approaches in our counter-trafficking response, and to always make sure that we're balancing the rights of victims, the rights of people who are on trial, and checking in that we're taking a holistic approach to trafficking that draws upon expertise, not only of criminal justice practitioners, but also other experts beyond it. Thank you so much. It's an honor to be sharing the screen with such esteemed colleagues. Thank you.
Thank you so much, Marika. And I agree with you. It is a complex issue, and which is why there should be more conversation about it. And of course, excellent discussion and advice from all of you. And I wish we didn't have to end this discussion, but I know for Pam and Justice Adele may need to go and grab their breakfast as this webinar started at such an ungodly early morning hour from your end. And of course, Marika needs to grab her dinner. So please accept our warmest appreciation to all of you, our esteemed expert panels today. Hungry we may all be. One thing for sure is that we will always be hungry for to learn more, no? About trafficking every day, and of course more about this vulnerability issue. So thank you, Justice Adele, Honorable Pamela, and Attorney Pa Agustri, and Dr. Marika for filling that hunger today about vulnerability and its evidentiary challenges in prosecuting TIP cases. There are so many justice practitioners in the room to give you that information, and they're very grateful for all the information that was shared today. So now, to formally close our webinar, may I invite our Deputy Team Leader, Mr. Aaron Rosada, to share his closing remarks. You have the floor, DTM.
Thank you very much, Dan. Briefly, because I know we've run over time, on behalf of the ASEAN Australia Counter-Trafficking Program, I would like to express our sincere thanks to all the participants who joined us today. We greatly appreciate you taking the time to join us, and we hope that you found the webinar insightful and that it will serve to influence and promote improved evidence gathering and the presentation of the abuse of a position of vulnerability in trafficking and person cases. And we're very pleased to see the numerous diverse participants joining from governments and also from civil society in the ASEAN region and in other parts of the world. We greatly appreciate the strong support from the Australian government's mission to ASEAN and the opening message from the Acting Council for Development, Danielle Siva, which set the focus for today's event. To our panelists who generously shared their time, insights and expertise, I don't think I can put it any better than Darlene, but thank you very much for your contributions to our event and for enlightening us on such a complex subject matter. It was great to hear the various perspectives about vulnerability and also the evidentiary issues on how the abuse of a position of vulnerability is proven in court as an element of trafficking in persons. As we heard from our speakers, victims are vulnerable. This is one of the reasons that makes them easy targets for traffickers. Lastly, to wrap up, a special thanks to our interpreters supporting us today with their excellent work that they do. So you enable us to reach a broader audience to further our program's impact. And lastly, to the team, special thanks to ASEAN-ACT, who have worked tirelessly to bring this event to you. Our next and last webinar for the year will be held on December 9th, and we look forward to you all joining, and it will be on the topic of the recovery of the victim from the trauma of being trafficked and the reflection period they are given to recover. So we look forward to seeing you all again next month, and thank you all again.
Okay, thank you so much, Aaron. Couldn't agree with you more. This really has been a very fruitful webinar with the champions in the room, with our esteemed panelists. So, kind reminder to everyone to please fill up the one-pager feedback survey. So just click on the link. I think our colleague Shirley has been sharing the link again and again so that you don't have to worry scrolling up. And please, would love to hear your feedback and how we can better improve the webinar. And of course, to reiterate, your comments matters to us. So we won't take much of your time. Your certificate of attendance will be sent to the email address that you provide in the survey. So again, the link will be posted. This Zoom webinar will, as you know, is recorded. So you'll see the recording of this that will be uploaded in our portal. The portal, again, link will be posted here so that you can easily access the Zoom link recording for those who get slugged out and miss some parts of the discussion. So you can access all the PowerPoint presentations as well and materials, the PowerPoint presentation all in English. So see you in our next webinar on December 9, another very interesting subject matter about reflection and recovery period for the victims of trafficking. So that would be our last for the year, and we hope to see you again in our next webinar. So thank you again, everyone. Thank you again, Justice Adele, Dr. Marika, Honorable Pam, and Pa Agustri for patiently staying with us. Terika Masi, beyond the 2-hour discussion for the webinar. Stay safe and
Terima kasih semua.
keep well. Bye. Stay safe. To all the interpreters, thank you so much. And then, of course, to all the team, thank you. Participants, thank you everyone for joining.